Hi, folks. I shut myself off accidentally there, so we will start again. We are still in the purchase and sales agreement on the next to the last page under buyer's rights. We're all the way down at the bottom of the page. We're talking about cesspools. The last point I wanted to make about that is that if you are buying a piece of property where there are not municipal sewers, and if you have reason to believe that somebody might be lying to you about the existence of municipal sewers or not, the easiest way to tell is to call up the city or town and find out if the house is connected to municipal sewers. If it is not, you need to get an inspection. You need to make sure that um, you do not fall within the new septic removal requirements, because the process can be quite expensive, and as a buyer you don't want to be getting a notice from DEM a few months after you bought the property saying, hi, you've got a year to upgrade your septic system while we're shutting down your house. All right. In our agreement, we did not particularly like the language that the legislature said had to be used about inspections, so we have added additional language, again, giving the buyers 10 days to inspect, but also giving them 5 days after the 10 days to tell the seller what it is they're looking for out of all the things found in the inspection. What will they let pass? What will they demand be fixed? What are they looking for in exchange? Where we've gotten into additional terms, very often there are things that aren't within a standard agreement, and these end up in a last ending clause just added on as an addendum. Here, apparently already there were issues with the air conditioner condenser, and the seller agrees that they will replace the same and let the buyer's home inspector inspect it prior to closing. The seller is also agreeing to pay up to $5,000 of buyer's closing costs and prepaids. One of the most interesting things that happened over the last 25 years is that, for reasons that are not clear to me, the banks and the federal governments who regulate the mortgage industry and bank lending policies have allowed situations where the sellers are allowed to pay the closing costs for the buyers, thereby allowing the buyer to borrow more money towards purchasing the house. It's kind of a strange reality, because in effect what happens in most transactions, I'm trying to sell the house for $200,000, and I finally tell the buyer, I'll go with you for 200,000. The buyer comes in and says, well, I can't do that. I need $5,000 in closing costs. Very often the parties agree they'll raise the price to 205,000 with a clause saying 5,000 that goes back to the buyer in closing costs. So it's a very interesting thing, but a very common thing, particularly when people are borrowing 100% of the mortgage money, or less, more than 80% of the value of the house as their mortgage. There are all kinds of restrictions, and this is one way of getting around some of the regulations, where the buyers don't have to show they've got money in the bank, or that they've been able to acquire a certain amount of money to pay for the closing costs, because the seller is going to pay it for them. It's part of the bargaining process, and again, any good real estate agent handling either buyers or sellers will have explained this to them at the beginning, and so when they get to the point of actually making an offer, trying to accept an offer, they'll understand that this is part and parcel of what goes on today. Finally, the entire agreement, we are making this an integrated contract, so that once this is signed, all verbal discussion, representations, thoughts, ideas, anything that went verbally back and forth between the parties is gone. Only that which is in this written purchase and sales agreement will be the final contract between the parties. Okay, so much for that. I have posted, and I will email to you, samples of 3 documents that we deal with in real estate closings. The first one is a warranty deed. And looking at the warranty deed form, you'll see we've got our parties from the purchase and sales agreement. We have the buyers, John and Mary Smith, listed at the top of the deed. We have the amount of the sale, which is required now under Rhode Island law and has been required for almost 100 years under Massachusetts law, listed. We have a word saying grant or give or sell or bargain and convey. There has to be some language saying that this is intending to give up the rights of the sellers to the buyers, and that nothing is being held back here. And again, simple word grant, sell, convey would work. Harry and Judy Jones are listing themselves as husband and wife, which means they can be tenants by the entirety. I'm not sure if we talked about it in the last lecture or not, but I'll go over it again quickly. There are three ways you can own real estate in Rhode Island as individuals, or as multiple individuals. One is as joint tenants, which operates very much like a joint bank account. If one of the joint owners dies, the other joint owner or joint owners become the owners of the property without having to go to probate court, and the family, the will, the estate of the deceased joint owner is cut off. They have no control or say over the property. Tenants in common, each owner listed on the deed owns a proportional share of the property, and if one of them dies, their share of the property goes to their estate. So it follows their will, or it follows the laws of inheritance, and therefore the remaining owner or owners will now have new owners tied in with them in owning this property. Tenancy by the entirety is reserved for specifically husband and wife and married couples, and this is one of the reasons why same-sex couples have argued vehemently and furiously in Rhode Island, Massachusetts, to be given the same status as heterosexual couples and mixed couples, because you can't get some of these rights unless you are recognized by the state law as being married. In a tenancy by the entirety, both husband and wife are deemed to own the entire property. And what that comes down to in practical terms is that neither one of them can sell the property, deed the property, put a lien on the property without the signature of the other. More importantly, for our times when everyone is suing everyone else in this litigious society, it also means that if one party gets sued and someone attempts to put a lien on the property, the other party does not have to bow down to that. There can be no forced sale. There can be no demand for payment of the individual who's being sued's equity out of the property. The other part of the marriage can just sit there and say, no, I'm staying on this property. And if the person who was sued and had the judgment against them dies first, the entire property goes to the other spouse, because in this way it works like a joint tenancy, free and clear of that lien. So it does give protection from lawsuits. And the interesting thing in Rhode Island is that this does not apply just to the property that you live in, but it applies also to any property that you buy as a married couple and you keep in your names as a married couple. So it does give a certain amount of legal protection to married couples. In both a joint tenancy and a tenancy in common, if one party gets sued and there's a judgment put against their interests, the judgment creditor can go to the other parties and demand payment and force a sale of the person who was sued interests, which creates all kinds of issues. So it does give more protection than you have in other situations. If you notice, our deed states that it has warranty covenants. There are basically three types of covenants that you can get. There are warranty covenants, quitclaim covenants, bargain and sale covenants. Warranty covenant says that you as the sellers are promising that the title to the property is good against all the other 7.5 billion people on the planet, and if anybody shows up to challenge the buyer's title, you will warrant and defend them. You will guarantee them and defend them in court. Quitclaim covenant means that during the time you have owned it, you've done nothing to muck up the title to the property. And if anybody shows up claiming that while you've owned the property, something happened that they now have a right to it that wasn't disclosed or taken an exception to by the buyers, that you will defend them. Now, just a matter of custom, in Rhode Island, we always use warranty deeds. In Massachusetts, we always use quitclaim deeds on residential property. No particular reasoning for that. It's just been the custom for several hundred years. There are deeds without warranties at all. They are called bargain and sale deeds, and they are basically, when you sign one of those, you're basically telling the other side, if you think I own an interest in this property and you're willing to give me money for it, well then good luck, I'm giving you whatever I have, but you can never come back after me for it. We very often use these to clear title. In certain institutions that will be here for a very long time, such as Brown University, Rhode Island Hospital, they also tend to use bargain and sale deeds because they don't want to create warranties and covenants that could last for hundreds of years. In the middle of our deed is what's called the legal description. Now, I talked about this earlier, and on our purchase and sales agreements, we attach this as an exhibit. The legal description is giving us a reference so we can tell on the ground that our surveyor could go out and figure out exactly what is this parcel, where does it sit, what are its boundaries, who are its abutters. There are basically two types of legal descriptions. One is a reference to a recorded subdivision plan. And the first paragraph here basically is one of those types of descriptions. It lists 4 lots on a particular plan that was recorded in 1919 and lays out what the boundaries of this lot are supposed to be, or what our parcel is supposed to be. Again, in order to do the title or do a survey, you would have to go to the town hall in Rhode Island, the county record hall in Massachusetts, find that plan, see what the boundaries were of these 4 lots, and then go out and see if you could find that on the ground. All right. The next description is one called a meets and bounds description. Meets and bounds is Old English for the angles and the boundaries and the number of feet in the boundary line. This is a very simple meets and bounds description, but some of them can run into multiple 300 and 400 courses of lines and all kinds of angles and whatever, and would require a CAD program almost to unravel them. But depending on the history of the property, you may be stuck with only one or the other type of description. These are required. These are considered necessary to convey title. You cannot convey a warranty title or a marketable title just by saying the property located at 32 Main Street. Now, having said that, you'll see we do reference the property. We do reference the assessor's plat and lot. This is to help the town officials determine what has gone on with the property, determine what property we're talking about. There is language there saying that Mary and John Smith are in compliance with Rhode Island General Laws 443071.3. That is a law that requires a withholding from non-residents. So by putting that language in, Mary and John are stating that they are Rhode Island residents and that no withholding tax is required. The next statement is one saying that they certify they have provided a smoke detector certificate and they've complied with the smoke detector laws for the property. Going on to the next page, the final paragraph is what we call a deed reference. Now, when we do a title exam, in Rhode Island we have to go back 40 years, in Massachusetts 50. When I first became a title examiner years ago, we had to go back 70 years, which was actually at that point in time bringing us into the early 1900s. Part of the examination is to find every prior deed to this property during that space of time. And there are ways to do that through the indexes, but they're very cumbersome and time consuming. So over the years, the attorneys who did conveyancing developed the system of always putting a deed reference into the document. And what that does is, if you want to see where the Smiths got title to this property, it's telling us go look in book 120, page 446 in the Ashaway records, and there you'll find the deed into them. And hopefully their deed will have a reference, will let you get back, and by hopscotching backwards, you can quickly go back 40 years to find what has happened with the property. Again, coming back to the statute of frauds, I want you to look at what's going on here. John and Mary Smith are the only people signing this document. Now, I didn't point it out, but on the purchase and sales agreement, all 4 parties signed. That's because both sides have rights and responsibilities under the purchase and sales agreement. Under the deed, only one party has responsibility. That is the Smiths, and their responsibility is to give good title. So we don't need the buyer's signature at all. It's just the Smiths giving it over to the other party. And if you see, there's a notary clause. There's a place for a notarization to take place. Under Rhode Island law, all documents to be recorded in the land records, at least all deeds and mortgages, must be notarized. And the notary must sign their name below the signatures of the grantors of the property. And within the last year and a half, Rhode Island has copied what was a rule in Massachusetts for over 100 years, which is you are required to have a notary seal on the deed, or it is not eligible to be recorded. Prior to that, the notary just had to sign. They did not have to put their seal. And if any of you have ever seen legal documents, you know a notary seal is a stamp or the embossing thing that allows you to tell that this was truly a notary and just not Joe the Barber signing, pretending to be a notary. Okay, putting that down. Excuse me. All right, the next document I want to look at is a promissory note. Now, under the terms of our purchase and sales agreement, the buyers, the Joneses, needed to borrow $400,000 to make this transaction work. So they went to the Ashaway Credit Union and they borrowed $400,000. There'd be tons of paperwork involved, and those of you who work in law offices and have done closings, you know what's involved. But the basic document in all of those 120 pages is this. It is the promissory note, which is the contract between the Joneses and the credit union, stating that the Joneses are obligated to pay back $400,000 to them with interest. Now, the promissory note states all the basic terms of the loan transaction. So right away, first part of it is saying that the borrowers have received $400,000 and they promise to pay it back to the Ashaway Credit Union. The language under Ashaway Credit Union makes it very clear. Ashaway can sell this loan. They can transfer it to somebody else. And any of you who have owned real estate will know that this happens quite often, that very often the smaller banks only act as conduits for setting up mortgages. They make their money in the fees that they charge for doing that, and then they sell the loans off to other third parties who have the right to collect the money. This is part and parcel of the mortgage business and trade at this point. There is almost no way to prevent this from happening. Some credit unions do have loans that they say they will keep in-house, but in the actual documentation, they will almost never certify that because of various banking regulations and different levels of what percentage of their debts can be mortgages versus car loans and personal loans. They're very loath to promise that they'll never sell your loan because at times, to meet federal regulations and other requirements, they may have to sell mortgages. Next thing, money is never given for free. So there is interest charge. Interest is what you pay for the price of using someone else's money. It is computed over time. The normal reality is that interest rates are charged per year unless stated otherwise. And here they come out and state it directly. I like this promissory note because this promissory note actually uses a lot of everyday language. Some of the other promissory notes in circulation are very legal mumbo-jumbo-y, and instead of saying at a yearly rate, they would say per annum, which is not even English, never mind legal English. But this particular form of note is meant to be a consumer-friendly note. So it's telling you right there, interest will be paid until every penny has been paid back to the $400,000, that the borrowers will pay this at a yearly rate of 3.25% of whatever's outstanding. All right. And time and place of payments. Banks and credit unions like to have payments made on the first day of the month. It makes it easier for them to sell these notes and the loans on the secondary market. So what happens at most closings are, if we're in the middle of the month, there'll be an adjustment for interest for those few days of the month until we get to the first, and then your regular payment on the note will start on the first of the following month. All right, so here we have the payment set up, and based on that interest rate and borrowing $400,000, to pay principal and interest will cost $1740.83 per month. All right. Number 4, the borrower's right to prepay. Many loans are written with what are called a prepayment penalty, which is if you pay it off early, in addition to paying the interest rate, you'll have to pay just a set penalty for not keeping the loan. Remember, the banks make their money by having these loans in place and collecting the interest. So once you sign this note, they think that for 30 years they're going to have a set amount of money coming into them. And that's another thing I didn't say, but look at this note is due on July 1, 2050. It is a 30-year note just by virtue of the date set there. All right. This particular loan and most consumer mortgages for residential property are loans that do not have prepayment penalties. So you're free to pay them off early, to refinance them to a better rate to a different bank, and that you'll have to pay whatever principal and interest you owe to the date of the closing, but nothing more. Going down to default. If you do not pay on the payment dates, you're in default. If you're in default, the lender has the right to send you a notice saying that you're in default and that you have to pay them X amount of money to bring the loan back up to date. If you do not meet that, then the lender has the right to call the entire loan due and payable. This is called acceleration. And if you become severely late on the note, the lender has a right to send you a second notice saying we are now accelerating the note. The entire amount of principal, interest, and collection fees are owed immediately. And if you do not pay, then they can begin the foreclosure process within so many days after sending you that notice. The only other thing I want to speak about here, one clause I notice I left out in this. Most residential mortgages for consumers have a clause that say you have a 15-day grace period, after which you are charged a 4 or 5% amount of the monthly payment as a late fee. But if you get your payment in during that time, there's no penalty. You're not technically in default. So normally they're not counting you in default until you've probably gone 30 days into the loan. This note, if you go down to the very last paragraph, is a note that is due on sale. The interest rates are incredibly low at this point. They're the lowest I've seen them in my lifetime. There is no doubt as the economy tries to recover from all the disasters that have been happening, interest rates will probably rise. So several years in the future, somebody might want to buy this property, notice that the Joneses have an incredibly good low interest rate, and say to them, hey, we'll buy your house, we'll pay your equity, but don't tell the bank, we'll just keep making the payments at the low interest rate. If the bank discovers that happens, which all they need to do is go to town hall and look at the deed or look at the tax bill to find out that that happened, this provides that they can then call the loan due and payable, foreclose on the property. And the reality is that the Joneses, if they did that, they're not free and clear of this note. They're the ones who signed the note. So if at the foreclosure, for some reason, the bank doesn't get back all of its principal, interest, and fees, then the race will be on to chase the Joneses to get the rest of the money from them. Okay, next document, last one, is the mortgage. 16 pages, most of which is there because we have tried, the federal government insures most of these mortgages today through the FHA, the VA, Fannie Mae, Freddie Mac, and because of that they've tried to standardize things, and that is a difficult process because all the 50 states have various different rules and laws about property. So in order to standardize everything, we end up with this humongous document. Basic things here. The language in the document follows the promissory note. It says that the parties have borrowed money from Ashaway Union. They are taking out a $400,000 loan. This mortgage is meant to be security for the loan. Now, an interesting thing, when you borrow money and you use it to buy a property, colloquially we say, oh, I'm going to the bank to get a mortgage. You are not getting a mortgage. You are giving a mortgage to the bank. You are signing this document which gives the bank rights in your property. All right? Going through all these pages, they say a number of things. Basic thing being that if you do not pay your principal and interest, the bank has the right to foreclose. Foreclosure means that without any further signature from you, they can sell the property at auction, take whatever money they can get for the property, and if that doesn't pay everything that's owed, still chase the mortgagors for the balance. All right? So this is a security agreement. It is referring back to the pre-existing loan that was set up under the promissory note, and it is basically saying that the bank will use the property to get their money back if you do not pay. Now, along with that, this contains all kinds of provisions saying that you must keep the property in good repair, you must keep your insurance on the property, you must keep the taxes paid up to date. For some people, particularly if you've borrowed a great deal of the value of the property, like the Joneses have here, this provides that taxes and insurance will be escrowed, which means along with your principal and interest, you're going to pay the bank every month part of your taxes and insurance so they can make sure that gets paid. You must maintain the property. You must occupy the property as your primary residence for a certain period of time. You can't be using this type of loan, this type of mortgage for a commercial situation where you're buying the property to flip it, or you're buying the property to put tenants in there. All right. Rolling along. Again, most of this is us all kinds of federal regulations to make sure that things are moving along according to federal law. When we get to page 15, there are a couple of things that are actually Rhode Island provisions that they've worked into here. Under our rules and our laws in Rhode Island, we have the legislature has passed a set of laws stating how mortgage foreclosures are to be conducted. And if the lender wants to take advantage of those rules and follow that procedure, then they must have this language in the mortgage, the statutory power of sale. So that means that this mortgage is subject to the statutory rules for foreclosing on property set out in the statute books of the state of Rhode Island. And should the borrower stop making payments, then it is under that procedure that the lender will go forward to foreclose. There is also another term called mortgage covenants, which they don't always use in these standardized forms. But if I were to write a simple mortgage for between private parties, I would use mortgage covenants. And mortgage covenants, again, are promising without having to write it into the mortgage that you'll pay the taxes, keep insurance on the property, pay whatever municipal items there are, water, sewer, fire districts. Now, again, I don't think I pointed it out on the promissory note, but go back and look there and look here at the mortgage. The only people signing this are the Joneses. The bank doesn't sign anywhere. And the reason for that is all the rights are being given up by the Joneses, not by the bank. The promissory note says the Joneses owe money to the bank. The bank doesn't want to get sued on the promissory note, so the only signatures that are required under the statute of frauds are those of the Joneses, allowing them to be sued if they don't pay. And here, it's the Joneses' right in the real estate that's being given up as the mortgage security. The bank's not giving up anything. They're getting everything. So we don't need the bank's signature. We just have the Joneses making 16 pages of promises. Their signatures appear. And again, promissory notes normally do not get recorded in the land evidence records. As a matter of fact, if they do, they create kind of a cloud on the title that can become problematic. Instead, we record the mortgage, which is the evidence showing that a promissory note existed. And because it is recorded, it must be notarized. It must have the notary signature and stamp on it with the same formalities that the deed did. All right, that ends our discussions on handout 10 and the associated documents. Over and out. We will start up again with a new recording covering handout 11, which is about borrowing money and loan transactions.